Regional Human Rights Moot Court competition took place on the 29th of June 2023 at Mount Kenya University, Rwanda. The theme for this season was on climate change refugees and enhancing government transparency and accountability in the promotion of human rights. Mount Kenya University Law Parklands was privileged to be part of this competition.
Hello viewer, welcome to Liberty Media. As Amanes put it, we are privileged to be visited to have these particular guests who are going to share with us by and large as far as the moots and the mooting processes of the competition is concerned. On my right here, I'm privileged to have a gentleman who is going to suppose to introduce himself, and he's going to briefly, after he has introduced himself, share with us by and large what exactly, in a nutshell, went down in Rwanda. Welcome.
Thank you so much. My name is Okechmak, student at Mount Kenya University Parklands. At school, I hold the position of president of the ICJ, Mount Kenya University, and I'm also a judge sitting at the ICJ. With me, mooting in Rwanda was a nice experience where we won alongside the best orator, Moses Mumo, and our moot court chair, Mount Kenya University Parklands, Rotich David.
That sounds very interesting. It must have been the whole one-time experience that you had down there.
It was a really thrilling experience. What I would say, it was the best platform to learn, relearn, and unlearn. Equally, we had this strong zeal that we are going to win. That was out of avid preparation. The team that was construed, Moses Mumo, Rotich David, and I, we had all been best orators in various competitions. So it was equally a strong team. We also worked with a good team of researchers who are Jeff Uluoch, Genevieve Some, and Lewis Mongare. So the team basically was an awesome one. Yeah.
I'm Rotich David, law student at Mount Kenya University Parklands Law Campus. The current Moot Court Committee chairperson for 2023-2024, an ardent mooter, lover of the law, Pan-Africanism, and philosophy. When it comes to the physical infrastructure, insofar as issues and things like lecture halls, the way the campus is set up, it does not really have much difference with the campus that we have here in Kenya, taking into consideration the fact that the campus is student-centered, well accustomed for students of the law. But when we proceed further beyond the physical infrastructure, we tend to appreciate more the kind of legal system that the Rwandese people have. And we were as intrigued as we were very much surprised when we learned that the legal system that the Rwandese have.
Mooter or a perfect mooter, I believe it starts from research. You can never ever go to moot if you are not a perfect researcher. What are you going to moot if you have not researched? I believe what helped us is we did an amazing research. Our research was on point, so that when the judge was asking us any question, we had a response to that question, and we could, match what the judge is saying. So I believe what makes a perfect mooter is research. In my perspective, is just research. The rest come later. You can't be confident if you've not researched. Even the best of oralists, the people who just know how to talk, as long as they've not researched, they will have some sort of fear. So it starts from there, which based the entire theme is one I was handling: climate change refugees. People flee their countries of origin and they go to other countries to seek refuge. But then normally it has never occurred. It occurred in one case, but before that it has never occurred that someone has fled their country on reason of environmental degradation or climate change. Because if you go there and you say I've fled because of climate change, you ask, okay, now we are to grant you refugee status or not grant. So the only case that entertained that was the Ionte Shorter v. New Zealand by the Human Rights Committee. it is the first ever case that dealt with climate change refugees. Now, to us, when we are talking about that, well, when you're the applicant, you have to show them, well, these people, the Atlasians, need to be granted refugee status. Where they're coming from is uninhabitable. They cannot live. They are dead, and even the people who are deported, 103 persons died. So we are trying to convince the court that these people have to be granted refugee status. On the other hand, we are the respondent. We are now saying, well, we consented to certain obligations, pacta sunt servanda, and we consented to only 5. Out of the 5, does the court identify climate change as one of them? No, which means we have no so women. As you see in the case, there was a festival, and then women who did not accept to what I was calling to bow down to Kenyan gods was stripped naked, publicly humiliated and all. And the government sort of did nothing, according to the applicant. But then in the respondent, we were saying, well, the case was brought, we investigated, we arrested, and there was no case. So we can't just take hot air to court. Exactly. I believe that is what my issues. Yeah.
When do we have to say now that this country or these people, they really deserve the refugee in the name of like a climate change? Is there a certain threshold?
Well, I will use the words of the Human Rights Committee in Shota in New Zealand, that there are grounds that you're faced with as a person, and those grounds are not expressly and explicitly stated under Article 1A2 of the 1951 Convention on the Status of Refugees, but the conditions amount to persecution. That is simply to mean that should you continue to stay in that area, you will die. So that amounts to persecution on cumulative grounds. Therefore, people are supposed to be granted refugee status should there be persecution. But the persecution that is expressly known is the 5 grounds: race, religion, nationality, membership of a particular social group, or political opinion. But then there is another ground that was created on cumulative grounds, that if we send you back, you experience some certain conditions, but the conditions are not expressly stated under Article 182 of the 1951 Convention, you will die. Those conditions are on cumulative grounds. So I believe if the threshold is met, but the threshold is high, as that case I've mentioned, Shota v New Zealand stated, the threshold is that you need to prove that should you go back to this country, you face an imminent risk, threat, that to your right to life, that should sending you back will, in some sort of way, just some sort, it is not in the literal sense, but in some sort of way, will amount to an arbitrary deprivation of your right to life. Yeah. The threshold is that high, that the applicant has to show that sending me back, I'll die. But there has to be evidence. But in this case, there was evidence that even before the people fled into Kenya, some persons had already died.
To the third right, it's of utmost importance that I mention the first issue which I handled, being the first counsel and also the lead counsel. I handled the issue of admissibility and jurisdiction. You know, before approaching any court, especially international and regional courts, you cannot enter and start submitting your issues without the court ascertaining whether it has the authority to entertain the issues that you are presenting before them. That is what we call in legal terms jurisdiction. And the court also has to ascertain whether the issues that you are bringing before the court are the right issues before that court. That is what we call admissibility. Are the issues admissible before the court? So of course, as the applicant, we were arguing seriously, and I personally was arguing vehemently that the court has jurisdiction and the issues before the court are admissible, taking into consideration the provisions of several regional authorities, and of course especially the protocol to the International Covenant on Civil and Political Rights, especially its provisions under Article 5.2 on the guidelines on admissibility. That is, one, before anyone comes from his country of origin and approaches a regional court, they have to exhaust all the local remedies within his or her country before now they decide to approach the regional court. When we went to the respondent, of course, we argued on the same seriously against it, and of course, on the grounds of exhaustion of local remedies. And we have so many laws around that issue. It's a very pertinent issue when it comes to regional and international courts. On the issue of the right to freedom of expression, especially the International Covenant on Civil and Political Rights, it's Article 19, that's the ICCPR. It provides specifically for the right to freedom of expression. And of course, the kind of freedom we are talking about here is a replica, or we can take the example of the provisions of Article 36 of the Constitution of Kenya. That is to say that you have the freedom to express yourself, in any other way. You can use the media, you can use your mouth, actions, drama, and of course, specifically on this case, the parties, specifically a gentleman called Dan Ben, seem to violate this right to freedom to expression. As the applicant, you were contesting that he did not violate it, and the government was saying he exceeded the limits of his rights, and my good friend Momas mentioned that there are limitations to law, where your right ends, another right of another person begins, So you cannot claim to be exercising a right beyond what the law provides for. Specifically under that provisions of Article 19 of ICCPR provides for us the limitations, the guidelines for limitations, as it must be lawful, reasonableness, and you can see they are much alike the provisions of Article 24 of the Constitution of Kenya. And of course, we have so many case laws, including Salmon versus France, a 1996 case law, which provided for guidelines on when it comes to these limitations. Lohise Konate versus Burkina Faso before the African Commission of Human and People's Rights. So it has always been an issue, the issue of limitations, because we were very careful, or the law is always very careful to ensure that the government does not, in the guise of limitations, infringe the rights of its citizens. So of course, I was handling the issue on the freedom of expression, and ideally in Kenya, for instance, we usually tie it with Article 37 of the Constitution, that is picketing and demonstrating and whatnot. So ideally, that was the issue I was handling, apart from issue 1 on admissibility and jurisdiction. And before I conclude to add, you realize that if issue 1 is not successful, if the issue on admissibility and jurisdiction is not successful, then the other issues will not matter.
I should say that this has not been just something we woke up to and we said, well, we're going to win this. It took us a consistent practice. Consistency, as I said at the start, is the 3 of us who mooted have all been best orators at the moots we've been to. So it was a combination of best orators. Well, what does it take? What can it?
We usually advise our learning friends that if you do not have the law comes first. If you do not have the law, argue the facts. If you do not have the law, argue the facts. If you do not have the facts, yell and bang tables, and shout at the top of your voice, and hope
for the best.
That of course they will be empathetic and sympathetic.